you had mentioned a tool before as far as communicating, and I'm guessing it's one of those tools that tracks every single message. Like it has read receipts, it has whether or not a party replied. What was that tool called?
Yeah, Talking Parents is the most commonly ordered here in Southern California.
Okay.
It's almost a boilerplate order that gets put into any custody dispute. If you guys can't get along, you're going to use Talking Parents.
We have, or I guess in Southeast Kansas, I'm trying to get it more involved in Southeast Kansas, but I have cases in Johnson County, Wyandotte County, and Miami County. In those three counties, that's the KC Metro. So in the KC Metro, it's kind of a default setting to use what's called Our Family Wizard, and it's kind of the same thing. Yes. So John Todd said, "Our Family Wizard, my man." So that is a default setting in those counties where we don't have that in Southeast Kansas. Judges aren't really privy to it yet, but I've tried to get it instituted. But that kind of goes along with my point in text, email, everything documented, everything written. Because if you talk on the phone, that's not documented. So it's going to be your word against her word, or her word against your word, or however it is. If it's written down, and in our family wizard, I think the judge actually has access to it. So if he sees that one party isn't responding, then he's going to be privy to that information, and you're going to get a great advantage if you head into trial with it.
And I think one of the big benefits of those softwares, this is from a selfish standpoint, those softwares are, from an evidence perspective, are self-authenticating. So you can't modify, you can't edit. I think it's $19.99 now to buy the transcript of Talking Parents, and you don't have to worry about. I think we've probably both seen where the client walks in with 5 years worth of screenshots of text messages. Those could be problematic from an evidence standpoint if they're contested.
Well, so if the text messages aren't time-stamped, dated, anything, I can argue foundation. I can object to a ton of exhibits coming in with text messages because they could have been altered. They're not original. They're printed off. It's a photocopy. They might not be dated in time. You can go into a bunch of evidence, but with Our Family Wizard and your tool out there, you can literally go in and print them off, and you can just probably take, if the judge has access to it, the judge can probably just take judicial notice of the file and say, Judge, you see on page and line that this occurred. That's part of our evidence in the case.
Yeah. And I'll give another example. I had one where the parties communicated via Instagram Messenger and Instagram video. So there was a good log of it, everything. Like there was nothing wrong. They weren't arguing that the messages weren't reliable, anything like that. But I ended up having to literally go to Instagram and get an encrypted version of a full transcript of the conversation. It took like 4 months for us to get that because they essentially argued if in theory, most states under evidence, if you present just a screenshot of text messages, if someone in a case involving a client of mine presents a text message, I'm going to object that it's not a complete record. That they're attempting to manipulate the situation. Like I had one where it was like a 5-year-old text message, and it was when the military had banned people who'd gone through. They were transitioning to the other sex. They were transgender.
Yeah,
and the guy the woman had sent the guy an article right when it happened, and he responded, "Oh wow, I didn't realize that scientifically was considered a mental illness." Well, they chopped off the article, and the conversation started with him saying that, and then the next message was, "When are you scheduling your doctor's appointment?" So they were trying to manipulate it to make it seem like he admitted he had mental health issues. Well, we show him we object, and then at the next hearing, we show him a full transcript, and it was like he was going to the chiropractor he'd thrown out his back. He was like a blue collar worker, and we showed him like they were talking about the military, and the judge, they're human. This person just blatantly lied, the attorney and the client. That's going to give you a huge advantage if it's a he said, she said situation.
Absolutely.